Thank you, Madam Chairwoman. I have in the audience today my page Samantha, who's an 8th grader, coming here to help shadow and learn more about what it is to be a legislator. I don't know why she picked me, but I'm appreciative. So thank you very much.
Welcome to our committee, Samantha. We're glad to have you. Also want to welcome Representative Sutton, who is filling in for Representative Williams, who is on a very exciting adventure that maybe we'll hear more about next week. Okay, so with that committee, I'm going to go ahead and, what? Did you want to, okay, thank you. Okay, committee, we're going to go ahead and open the hearing on Senate Bill 84, and I will ask our reviser to give us a brief. Thank you, Jason.
Thank you, Madam Chair. Good afternoon, committee. You have hopefully the bill brief for Senate Bill 84, which comes to you, I'll get this out of the way at the beginning, via the Committee on Judiciary in the Senate and passed the Senate 39-0. The bill modifies the crime of criminal use of a financial card to include certain conduct involving gift cards. You'll see that a couple of items added are first, acquiring or retaining possession of a gift card or gift card redemption information without the consent of the cardholder, gift card issuer, or gift card seller. And the second added addition is altering or tampering with a gift card. You'll notice that the penalties for the crime are not changed, so they would be subject to the same penalties as under current law, ranging from a Class A non-person misdemeanor to a severity level 9 or a severity level 7, depending on the value of the property or goods. The section is also amended to add some definitions, beginning on the bottom of page 1 and then on to page 2. Cardholder, closed loop gift card, gift card issuer, gift card redemption information, gift card seller, and open loop gift card. And the last thing I'll say is that it would become effective on July 1st if adopted. Happy to answer questions.
Okay, thank you. Committee, do you have any questions for our reviser? Okay, seeing none, thank you, Jason. We appreciate it. I will go ahead and call our first proponent, William Wilk from the Kansas Chamber. Welcome to committee.
Good morning or good afternoon, Madam Chair and members of the committee. My name is William Wilk, Senior Director of Government Affairs for the Kansas Chamber of Commerce. The Kansas Chamber is also the state affiliate for the National Retail Federation, and on behalf of the Kansas Retail Council, we appreciate the opportunity to submit proponent testimony on Senate Bill 84, which modifies the criminal use of financial card statutes to include certain conduct involving gift cards. Gift cards have been the most requested holiday item for 17 years in a row now, and fraud and tampering with gift cards continues to grow nationwide, and it comes in many forms. One common example is the method of card tampering. Fraudsters will change or steal the card number details, and then when the victim, the customer, goes to activate the card, putting money on it, the fraudster can spend the money before the victim can because they see that money go onto the card. Senate Bill 84 will increase the penalties for fraudulent conduct involving gift cards. And over the last year, we have been hearing from our retail members about this nationwide issue of crimes and fraud around gift cards. This bill helps bring awareness to this issue, along with providing actions of accountability for law enforcement against individuals who commit these crimes. Attached in my testimony is a presentation on gift card fraud that was provided to me by the Council of State Retail Associations. This presentation provides much more in-depth information on the issue of gift card fraud. With that, I would like to thank you for allowing us to testify in support of Senate Bill 84, and I'm happy to stand for any questions at the appropriate time.
Okay, thank you. Committee, what questions do you have for Mr. Wilk? Questions? Representative Barth.
Madam Chair, and I do have a question for you. So the gift cards that are utilized that somebody gets a hold of, that they're taking the information so that when somebody does put money on there, that they're stealing the money right away. Is that happening at, you go to big box retail store and it's on the wall there and you just pick it up and it's in a little, envelope type of deal, but it's not fully secure?
Correct.
Is that how they're getting, what's the methodology, or are there other methods as well?
So what they do is they take those numbers, because gift cards, some like the Visa gift cards have a number like a credit card on there. And so what they do is they take those numbers off, and then when they see money goes onto the card to be activated, they'll spend that money before the consumer can. And so they'll have it written down and put it back on the wall. And
A few other follow-up questions.
Go ahead. Yep.
So is there a certain store that you're finding this in specifically? I mean, have they tried any measures like putting it behind, a locked glass case so that a store employee has to get it out so that they can't be tampered with? Are they trying anything at all to minimize this?
First, it is across several retailers. I know from several retailers to big box retail stores to small businesses. It was important that our retail members didn't want any mandate to where they would have to have it behind locked counters just to have it easy access to consumers. Because like I said, gift cards are a very common gift. But, they are looking at ways just to make sure that they can hold people accountable to these crimes and just to help combat the issue.
Okay, committee, any other questions for Mr. Wilt? Representative Curtis.
Thank you, Madam Chair. So thank you for your testimony. How difficult is it to find people who are they having any success in finding people who are actually tampering and stealing with them? Because I understand the increase in penalties, but what are the efforts being made to stop that before it gets to?
So within my testimony on that presentation, let me try to find the slide real quick. I know the Department of Homeland Security has issued a task force, I believe, to help, the Homeland Security investigation. I don't have numbers on the slide, but it's in that PowerPoint. And so they are trying to work on to combat people that commit these crimes. I've asked for data from our associations that we work with on retail issues, just for any Kansas-specific data that they're trying to get back to me, that I'm happy to provide to committee once I have that information.
That would be great if you could do that, just for information to pass along. And then just one other thought that comes to mind, if they are indeed stealing the numbers and everything, isn't there a way to address the packaging so that those numbers are then, or I guess that would be difficult then when you check out and then they can't put money on there.
Yeah.
So.
I have seen in videos, they're very clever with how they do this. They'll put resealing and put them back on the wall so retailers won't be able to notice that.
Okay, committee, any other questions? Okay, thank you. Appreciate it. Yep. Okay, committee, we also have written-only proponent testimony, Renee Hadley from KCK Chamber of Commerce. Please look at that. And neutral testimony from J. Houston Bales from the BIDS Legislative Committee. Okay, if there are no other questions or comments, I'll close the hearing on Senate Bill 84 and open the hearing on Senate Bill 241. And again, call on Jason Thompson, our advisor, for a bill brief.
Thank you again, Madam Chair. Senate Bill 241, again, comes to you via the Senate Committee on Judiciary, and it passed the Senate 40-0. It provides that restrictive covenants in certain contracts are enforceable and not considered a restraint of trade in certain circumstances. The statute that's amended is KSA 50-163, which thankfully I haven't had to deal with in quite some time. Those of you that were around for this restraint of trade debate, it was lengthy and difficult to understand. But thankfully here, we're just adding some provisions about certain covenants that are not going to be determined to be restraints of trade if they meet certain criteria. Subsection C is amended to add 5 types of covenants as not restraints of trade. And I won't go through each of them. They're outlined in the memo and the bill, but I'll try to highlight a couple of them for you. The first is agreeing to not solicit, recruit, induce, or interfere with employees or owners of a business entity if that covenant does not continue for more than 4 years, meets those criteria, right? Covenants, the second one is a covenant about interfering with a business entity's customers. Again, cannot continue for more than 4 years following the end of the business relationship with the business entity. The third one employees agreeing not to solicit, recruit, induce, or interfere with with one or more employees or owners of a business entity. If the covenant protects confidential or trade secret business information or certain other protected information or does not continue for more than 2 years. So you can see that they're very kind of specific to the kind of information that's protected, the kinds of covenants that are written, and the duration of those covenants can't be more than a certain amount of time, or they could be restraints of trade. So that's the idea with each of those 5 that are outlined there. I can get into more details if you'd like, or let the proponents get into that, but there are 5 kind of specifically crafted covenants that are deemed by law to not be restraints of trade if they meet the criteria of the statute. Last thing I'll say is there are a couple definitions added in subsection G, and the bill would take effect on July 1st if adopted. Happy to answer questions.
Yep. Okay, thank you. Committee, what questions do you have for the revisor? Okay, Representative Barth.
Thank you, Madam Chair. I feel like I'm the only one to ask questions sometimes, but I have a very curious mind. Okay, so now that we're getting all these Senate bills over, I just want to make sure I'm not confusing myself. Is this a brand new bill? Because I know that I see, it looks like amendments in what they did. Well, maybe not, that's just me. There are no amendments on this one, but is it current statute that they wrote, or is it all new statute?
Good question, Madam Chair and Representative. So I will try to be in the practice of, especially if the Senate amended something before they sent, I'll try to explain what the Senate amendments were. In this case, the bill as introduced was passed by the Senate, so there were no additional amendments. But yes, this is an amendatory section. So current law is KSA 50-163. That's the statute that's amended here. And in the typical fashion that you'd see in a House bill, same goes for a Senate bill. The language in regular type is current law, and the language in italics is new to the bill. So the things that are added here are, page 1, line 20 through 24, and then beginning on the bottom of page 1 onto page 2, that's all new language. Those are the 5 kinds of covenants that are added that are not going to be considered restraints of trade. So those were the things I was talking about there. Yeah. There will be different fonts at times, right? Some will be in bold or italic. And so, yeah, we'll get into that as the session goes on. It gets more confusing. So I appreciate you being alert for that now. This one's an easy one, thankfully.
Okay, while you're on that, I'm just going to ask a question. When it's in bold, it means they amended the bill over on the other side, or you just want to wait till we have a great example of that?
I mean,
Just, yeah.
yeah, Madam Chair, so the next step is bold italic. That's something that was added after the bill was introduced by the committee or the committee of the whole. And yeah, and those fonts are actually in statute. There's a statute that says what font has to be done for which version of the bill where the amendment was added. So we have no control over it. So it gets nice and confusing when you amend it at each step because each one has a different font or style to it. Yeah.
That's good. Thank you. Representative Curtis.
Thank you, Madam Chair. So I'm trying to read quickly, but could you just tell me, how does this affect, like, if an employer enters into like a non-compete clause, does this have an effect on that?
Madam Chair and Representative, it could. So the main peanut, and I probably glossed over this a little too much, in subsection B, that new language that still says, if a covenant, so an agreement, right, in writing, is determined to be overbroad or otherwise not reasonably necessary to protect a business interest or the business entity seeking enforcement of the covenant, the court shall modify the covenant, enforce it as modified, and grant only the relief reasonably necessary to protect such interest. So we're kind of saying to the extent you need to enforce the covenant, the court shall do that, but not more than necessary. And then the second part that I emphasized a little bit more was there are certain covenants that if they meet this requirement, so you have an agreement in writing where the owner agrees not to do certain things, and the length of that agreement is not more than what the statute says it can be, those are going to be deemed not a restraint of trade. They're going to be okay to be enforced. It just sort of gives statutory validity to those agreements. So if you're a business trying to write one of those covenants and you stay within the confines of the statute, you've got a better argument that your covenant will be upheld and your non-compete essentially will be upheld. I think that's what the proponents are getting into a lot more, but that's kind of the high level idea. This gives you guardrails as, you know, folks doing these covenants. What do you need to do to be within the statutory framework so that your covenant will be enforced sort of without any further question? Like, you are in the parameters of the statute, you're okay. That's the idea, yeah.
Right, so,
I think Representative Lewis, I don't think I was on the microphone when I said that.
what's that? Yeah, good. Thank you, Madam Chair. So just focusing on Section 1B, the italicized addition, which has to do with essentially the remedy that the court's going to impose once it determines that that there's a restrictive covenant that's overbroad. And it provides that it shall modify the covenant, enforce the covenant as modified, and grant only the relief reasonably necessary to protect such interests. So my first question is, doesn't the court already have that equitable power when it makes that determination? I mean, I don't think this suggests that current law requires it to excise the entire restrictive covenant. And I get maybe this is just a feel-good provision and not substantively changing anything.
Madam Chair and Representative, that I think you're right. Power of equity, the court could do that now. And maybe the goal, and hopefully the proponents can speak to this, is to make clear that the court shall not just void the whole agreement. It's maybe more to focus them on using the equitable power and only granting the relief necessary to protect those interests and voiding only the part that it has to. So it might be more to prohibit, well, not prohibit, but encourage the court not to do the other, which arguably they can do under current law too, right?
Thank you.
Okay, committee, do we have any other questions? Okay, thank you, Jason. Appreciate that. I will call to the podium. We have one proponent, Eric Stafford from the Kansas Chamber. Welcome to committee.
Thank you, Madam Chair, members of the committee. Good afternoon. Eric Stafford with the Kansas Chamber, here in support of Senate Bill 241 today. I think we all learned that Mr. Thompson's middle name is Times New Roman, as we talked font types and all that. But do appreciate the opportunity to be here today in support of this bill. I think the goal here to Representative Curtis and Representative Lewis' questions is to establish clear guidelines and limitations as to what constitutes a reasonable covenant. These are not non-competes, and we'll get into all those details today as to what these different provisions mean, because you'll notice some of the same language throughout the bill in the new sections. And the reason it's repetitive is because there's a provision that applies to owners and ownership interests, and there's a provision that applies to employees. But there's different time frames because there are different transactions and different relationships. So I hope to add some clarity to the questions that were asked today. Before I get into those details, I do want to point to the page 3 and 4 of our testimony. I don't think that, there is a page 5. So there are 3 pages of a proposed amendment that kind of add additional clarification to this bill from stakeholder interest. There's some businesses that are out there that had reached out asking, hey, we like this bill, but we feel like it probably would be better on some ownership provisions if we add some additional clarifications, but also had some feedback from the Kansas Trial Lawyers Association that there were some provisions that they wanted to have clarification to, so we took those into consideration and adopted those into the bill as well. So the red changes there are a combination of interests between several additional businesses that like the provisions in here, but also from the Trial Lawyers Association in terms of clear contracting between the employer and employee relationship. So, all that said, I'll get into the reasons why this bill is here before you. One other piece I do want to add. So the ownership provision is a 4-year prohibition on, again, something I'll talk about shortly, material contact customers, customers that have the individuals that they have a direct relationship with, right? Not any client within a firm, but those that they had direct relationships with. Ownership interests are a little bit different because they negotiate a transaction to sell their business interest or their ownership interest, right? So they sell that business. They have a longer window of the non-solicitation agreement versus an employee who doesn't have the ownership interest necessarily that an owner does. That's why the employee provision is only 2 years. Some of the additional feedback that we've received within the last couple days is that Kansas case law addresses a 5-year window on the ownership interest. There's some folks have an interest of extending that to 5 years. We don't have a problem. It was drafted as 4, it passed as 4. We don't have any problem if the ownership side goes to 5, but the employee provision, I think it's probably more important to keep that at 2 because those are different types of relationships. So, but I'll start in the details of 241. This does not address or provide any guidance relative to non-compete covenants, which can prevent somebody working in a geographical area or a specific industry. Those are often viewed by courts as overly broad compared to restrictive covenants. But even recently under the Biden administration, the FTC banned non-compete clauses and provisions. So the non-solicitation provisions, they're often viewed as the least restrictive means of a non-solicitation agreement. And as I mentioned earlier, the provisions of Senate Bill 241 have a specific time window of 2 years and 4 years, depending on whether it's the owner or the employee involved. Kansas does have pretty good case law on this, but we have been asked to pursue this legislation just to provide some further clarification for those working on this matter. Our case law is not as extensive as some states, but they felt adding these provisions would be good. Our intention to the reviser's comments about the Restraint of Trade Act, that was not the intention of how to draft this bill. And I believe Ms. Scott on the Senate side said, well, why don't we put this in the Restraint of Trade Act? And our folks felt like that was a good match. I did get to work on that issue back after the Supreme Court ruled on restraint of trade. I don't know, it was probably 12 years ago by now at this point. And that became a big issue here in the state. So, but that's why these changes are under the Restraint of Trade Act here in Kansas. So the limitations in Senate Bill 241, they are specific to a time frame, but also if you look at the definition of material contact customers, that's what it's tying to. The individuals that they have a direct relationship with, not, so if, say for example, I'm working for a law firm, engineering firm, and I have a direct relationship with Representative Schreiber's company and Representative Sutton's company, but I don't have a relationship with Representative Goddard's company, but he's a client. So he's not a material contact customer of mine. So reading through that language, they're trying to be respectful of and tie it to certain limitations, right? So you can't go try to get your book of business. If you sell that book of business as an owner or you're just an employee and you had a direct relationship with those individuals, again, it's important to tie that those are back to the material contact customers as defined in the bill. What we are seeking here is to protect, with these changes, the 2 most important assets of a business, the people and its customers. So Senate Bill 241 doesn't say employees or owners can't talk to or solicit business from any client. It's just, again, offering clarity of who they can and can't talk to for that restricted amount of time. The clarity is beneficial to employees who leave because it provides them a clear roadmap on what is an acceptable restrictive covenant, what is acceptable behavior for them in a new position, or if they start their own business, what is acceptable behavior for them in that new role. But again, I just appreciate the opportunity to testify today, and again, want to focus your attention on the feedback that we did receive. We started having conversations with the Trial Lawyers Association and some other businesses who liked this bill I can't remember what day our hearing was on the Senate side, but it was, I think, within a couple days prior to the hearing. So we said, hey, let's have some phone conversations. We did, took their considerations and their recommended language and kind of worked through all that and applied that in the proposed amendment that you have before you today. But we do believe this is simply a clarification bill just to kind of strengthen Kansas statutes and provide clear guidance, but would be happy to answer any questions that you have on Senate Bill 241, and we would appreciate your support. So thank you, Madam Chair.
Okay, thank you so much. Committee, what questions do you have for Mr. Stafford? Representative Carmichael.
Thank you, Madam Chair. I hope it's not out of place for me to observe. You might not want to use lawyers as an example because the Code of Professional Responsibility prohibits agreements of this type, and you get yourself disbarred for entering into those agreements. That being said, first, with respect to the length of time that the statute would permit an owner or former owner to be under restraint of a covenant, the Senate passed a 4-year maximum. Is that correct?
Yes, sir.
And is that still what the Chamber of Commerce is advocating for, or are you now wanting us to do something different than what you advocated for in the Senate?
There are, if you guys go to 5, that's fine. There are people asking for 5. If it stays at 4, we are kind of ambivalent. We've obviously supported the bill before.
Okay, and my second substantive question, as I read what looks like a red line, blue line type copy, but unfortunately it's in black and white when we ran it off. On the first page, no, correction, the second page of that document, about halfway down, there's a subparagraph 7. And I'm not going to read the whole thing, but it says notwithstanding the presumption of enforceability set forth in, and then it cites several KSAs and says an employee shall be permitted to assert any applicable defense available at law or in equity for the court's consideration in a dispute regarding a written covenant. Are you with me?
Yes, sir.
Then if I go back and look at those 2 sections of law, which I did not read the citation to, I find them on page 2 of the bill at lines 17 through 27, and then commencing again at line 28, going through line 38. And as I'm reading this, the amendment somehow modifies, or supposedly modifies, the terms of what's in the base bill that was passed in the Senate. If that is true, which trumps? Because I don't see, when you have a conclusive presumption in the bill that passed the Senate, and now you seek to amend the bill to add a different clause that says employees shall be permitted to assert any applicable defense available at law or in equity, that appears to be contradictory language. Is there a conclusive presumption, or is an employee permitted to assert applicable defenses available at law or in equity? I don't see how you can have both. Help me understand.
Sure. I don't know if I can help you understand. I think, so if you go back onto page 1 of that amendment in subsection B, where it says if a covenant, and then the new language that is in red, and if it's not going to show up on yours, it says that is not conclusively presumed to be enforceable pursuant to subsection C. I think that language, as well as this subsection 7, I think is the language that Sean from the trial lawyers requested to be included. I'm pretty certain that is tying in, because again, and I've got a color copy here I can provide to you, that language, they asked for that to be clarified.
And I believe you're referring to Sean McGivern.
Yes, sir.
Lawyer of excellent reputation in the state, and it makes sense now. I missed the qualifier on page 1, and I know that Mr. McGivern would never make an error of that.
If it's, when it's not in color, compared to looking at the base bill, yes.
I just missed it on the first page of the amendment, I'll confess. Thank you.
Okay, committee, any other questions? Representative Osman.
Thank you, Madam Chair. I have a question, and this question is not to accuse anybody of anything, but just to seek clarification.
Sure.
Are you aware of any business that has potential pending litigation or something of that nature to which passage of this will solve that issue or ease?
No, it's just seeking to provide more clarity, but no, this is not dealing or related to any litigation that we're aware of.
All right, thank you.
Okay, Representative Curtis.
Thank you, Madam Chair. Yes, I'm full of questions today.
Yes.
So do you, just a general question, do you see businesses moving away from non-compete and using this as a tool?
I think it depends on the business, right? But I think because of recent actions, I think non-competes are largely unenforceable. It kind of like HOAs, right? I mean, I think that's just how it's gone. So it's, instead of being overly broad and too restrictive, because you're preventing somebody from their ability to earn economically, having tightened restrictions specific to the business activity is considered to be reasonable. So I think people are learning and courts are deciding that overly broad language is largely not acceptable. So again, that's why this is specific time periods, specific actions, trying to be specific as to what is and is not acceptable. So both sides have a clear understanding.
Representative Lewis.
So you mentioned the FTC, and I'm just asking, or refresh my recollection. I know they issued some sort of rule or regulation or statement that they weren't enforceable non-competes.
I believe it was regulation.
But hasn't that been rescinded, or am I making that up?
If it has, I'm unaware. I'm not sure if that has. So yeah, I don't know.
Okay.
But again, it comes back to it's a rule, right? It's a ruling that had public comment, but it could be rescinded. I mean, it's executive power agency changes with the new administration. It very well could be.
Thank you.
Okay, any other questions, committee? I'm sorry, Representative Barth, thank you for raising your hand high.
Thank you, Madam Chair. I did have a question, and to me, when I was listening and reading this, and this is the first time that we've really had this brought forward to us, and I became aware of this, I'm pretty aware of the FTC banning that non-compete, and as worked for employers, I've always had a non-compete personally, and I am yet to understand what's the difference between a covenant and non-compete, though, from any of your testimony or anything in this bill. So is this just a way to get away with still doing the same thing that non-compete did? Because I don't see the difference.
No, I think non-competes could include and say, you cannot work in our industry for 2 years after you leave our job or this employment, right? Or you can't work in the Kansas City region for 2 years or 5 years after if we depart, right? So that is broad, and this is intended to be specific, tied to specific customers to protect their business interests, right? But also give you the flexibility as a former employee to be able to continue to still pursue employment, economic activity, wherever you want to be. But it's intended to be, restrictive covenants are intended to be the least restrictive as possible type of agreement between an employer and employee.
I do have a couple follow-ups actually on that.
Go ahead.
If you don't mind, Madam Chair. The non-competes that I have seen actually are not exactly what you described. They actually look a lot like this. So I'm not seeing much difference from a covenant to a non-compete. Part of what you said is partially true. Like, yes, that does occur, but they also cover other things like calling on customers, bringing over staff and things like that. So I don't see a difference. So I just want to clarify that unless there's a written definition that makes it different, I don't see the difference. And so I do feel like in a court of law, how would this hold up? And then especially when they have banned the ability to have non-competes. The other thing that I wanted to bring up that I had a question on is the 2 years for employees. That seems to be more stringent. And I believe that there should be protections for both employees and the employer, but that seems to be more stringent. I'm more used to seeing 1 year, 12 months, not 24. Coming from one place to another place, that seems pretty restrictive. When you said it's supposed to be less restrictive, it actually seems more restrictive. So if you could kind of provide me some information on that too. Thank you.
Sure, Madam Chair. To the first question, I haven't seen the non-competes that you've seen, so I don't know if I can speak to those. Other than to what is a court to decide? What is a court to decide today when there aren't specific provisions for them to determine what's reasonable and what's not, right? And that's the intent of this today, is just to provide further clarification for a court to consider, based on these factors, is this a reasonable restrictive covenant or not? I think that those who have been involved in the drafting of this have been very intentional about ensuring that they're not overly restrictive, again, tying it back to the material contact customers. But I mean, I can't speak to an agreement that I haven't seen or been a part of on that. And then I'm sorry, would you mind me the second question?
Yep. The second question, if you don't mind, and if you don't know it, then I'm going to defer to the revisor to clarify as well.
Yes.
So there has been, I know there has been some statute at some point in time on the non-competes and so forth, do we have a time frame that we know of that previously existed? Was it 2 years? Was it 12 months? Was it longer? Do we have any information on that previously? Because that would be helpful.
Yeah, Madam Chair, I
Right, thank you.
don't know the answer to that question off the top of my head.
I'm going to call on Representative Sutton.
Thank you, Madam Chair. I can't speak to every industry under the sun, but the last non-compete I had was 2 years. I don't know how much that helps you.
And then, yeah, I mean, it's helpful to know a real life example, but Jason, do you know anything else about that? Okay. All right, Representative Carmichael.
This is not at all my area of specialization in the law, but as a general principle, covenant means a promise. So I covenant that I will not use the secrets and informations that I learned while I was either your business partner or your employee to advance my interests in a different employment or in a different business relationship. A covenant not to compete, in very simplistic terms, says I won't go out and solicit your customers. I won't compete with you for the business, which is different than promising I won't disclose information that would be detrimental to you. And my recollection is that there's not a statutory provision, but typically covenants not to compete are determined based upon the factors of the nature of the particular business, the nature of the geographic scope, and generally it is a case-by-case approach without any specific time limitations. Now, there may be lawyers in the room who are more adept than I am on these matters, but that's my general retired lawyer recitation of something I learned many years ago.
Thank you. Representative Sutton.
Thank you, Madam Chair. In going over, we've been having a discussion about the difference between the covenant and the non-compete, but this bill actually looks like, unless I'm misunderstanding, and maybe you can set me straight on this, this looks more like a covenant not to solicit, which would be entirely different than a non-compete. Am I know I'm the new guy here. Maybe I'm missing something. Could you help me out here?
Yeah, again, that's why that language, it's specific actions, right, of what's acceptable. And I'm trying to find, recruit, induce, persuade, encourage, directly or indirectly, one or more employees or owners of a business entity shall be conclusively presumed to be enforceable and not to restrain a trade if the covenant is between an employer and one or more employees, and the covenant seeks on the part of the employer to protect confidential or trade secret business information or customer or supplier relationships, goodwill, or loyalty. So again, it's trying to be very prescriptive of how this is actually applying versus you can't work here or you can't work in this industry for an X amount of time. It's trying to lay out specific actions as to what deems reasonable and what deems outside of the scope of that.
Okay, committee, any other questions? I had one, oh, I'm sorry, Representative Carmichael.
Just real quick, and as I
Yeah.
sit here thinking, oftentimes it's described as a covenant not to compete, a promise not to compete. But there may also be covenants that you won't do other things with what you learn while you work for somebody else.
Okay, thank you. One last question I had was, I know this, I'm curious what happened. It passed on the Senate floor 40-0. Were they aware that you had some amendments coming up, and so therefore there was that, or did they, kind of what's the history a little bit as far as your
Sure.
amendments go and what happened on the Senate floor?
Yeah, Madam Chair, I stated during our testimony on the Senate side that we had been contacted by the Kansas Trial Lawyers Association prior to the hearing to talk through some language suggestions that they had. We said we would be willing to do that. The committee acted, Senate passed it, but around the time the Senate passed it, I think is when we got on our Zoom call. And then we had those conversations, said we would offer the language on the House side.
Okay. All right, thank you. We appreciate it.
Thank you.
Committee, we don't have any other proponent, opponent, or neutral testimony. Therefore, I will close the hearing on Senate Bill 241. I want to talk to the committee for just a minute about what the future will hold. Interestingly, we got 15 bills from the Senate that came over from, I think they were all from the Judiciary Committee. 15. We have 10 committee days after today that we have to get those heard and then, of course, worked. Plus, we have a few other House bills that are kind of dangling out there that we've not quite handled yet. So with that in mind, just make sure you look at the agenda for next week. We have 2 hearings on Tuesday. Right now, the agenda says 2 on Tuesday, but I think I'm going to change that to 3. I'm thinking next Thursday will work quite a few bills. And so I think everyone will be there then. So if we're going to have someone missing part of the week next week. But so on Thursday, I think we'll be working bills particularly. And then the next week kind of start over with hearing bills. And that's all we have on the agenda for today. And so with that, we're adjourned.